State's represented by Zachary Miller, and David Treptow is represented by Martha Lucey. You may begin.
Good morning. Can you hear me if I'm this far away?
Justice Appel, can you hear her? She's a little further back, or would you like her to step a bit closer?
She's fine, thank you.
Thank you.
May it please the court. I'm Martha Lucey, and I'm here today representing David Treptow. There appears to be no dispute that there is not a factual basis for the guilty plea to gathering where controlled substances is used. The question that this court will have to decide is, what or can the court do to remedy this error? If we were here a year ago, we probably wouldn't be here a year ago. This case would have been submitted to the Court of Appeals non-oral, or maybe even a motion to reverse from the state. But in 2019, the legislature changed the whole scope of guilty pleas, appeals from guilty pleas. In this case, there's no objection below that this guilty plea lacks a factual basis. So may this court consider an ineffective assistance of counsel claim? Under the legislation 814.7, the answer is no. You may not decide this, although I may raise it. Should this court adopt plain error review specifically to address this type of claim that can easily be resolved on direct appeal on the existing record?
Even if we were to adopt plain error review, isn't there still an additional problem with the failure to file a motion in arrest of judgment?
There is another hurdle, and that would be 814.29 that would require that the defendant show, but for the lack of factual basis to this guilty plea, he would not have pled guilty.
Well, but beyond that, I mean, if he didn't file a motion in arrest of judgment, we've usually treated that as an ineffective assistance of counsel claim for
Correct.
failure to file a motion in arrest.
Correct. But under here,
So, but even if we were to adopt plain error review, that doesn't stop the bar from Rule 2.24 that prohibits relief unless we can resolve a claim of ineffective assistance of counsel. Isn't that right?
I'm not sure I'm following your question, but if you adopt plain error, this case would fit within plain error, that there is an error, that there is not a factual basis, that the error is plain, it's obvious.
Well, I understand that, but doesn't Rule 2.24 say if a defendant doesn't file a motion in arrest of judgment, then he's barred from challenging his guilty plea?
I believe it says that the court cannot, I think it may actually say waive, but there's a difference between waiver and forfeiture.
Could I ask you about the point that you raised, Ms. Lucey? How do you get around that other provision in the statute that says you can't set aside a guilty plea unless you can show that but for the error, your client would not have pled guilty?
And what I would submit that this court should do is adopt a per se finding that if there is not a factual basis to a guilty plea, that the defendant would not have entered that plea.
But that seems inconsistent with the language in the statute, doesn't it?
Well, the statute is basically the Straw Hill standard, which has always been applied for cases of other guilty plea errors, but has never been applied for the factual basis, because the factual basis in a guilty plea should be an accurate accounting. If it's not an accurate accounting, then what is the point of having any 8.2b requirements if he is factually not guilty of this offense? Why should we not just correct it at the first opportunity? And so there is the difficulty with the idea of 814.29 requires this but-for test. And you see in the state's response is he got such a good deal, he would have pled guilty anyway. that should be troublesome.
I'm sympathetic to that argument and contention. I guess as a practical matter, if a practice develops where these types of claims are just immediately brought in post-conviction relief proceedings versus direct appeal, what is the harm?
Okay. And I think that leads me to a thing that I realized last week is, okay, I was trying to picture what would a PCR look like for a factual basis claim. And so the interesting thing is that he would have to say there's not a factual basis, whether it's ineffective or not. And the defendant would, or the petitioner has the burden, no factual basis, lawyer should have filed a motion to arrest a judgment or prevented me from entering this guilty plea. And under existing case law, prejudice is presumed, okay? So normally on remand, the state would have an opportunity to present different information. So in PCR, does the burden then shift to the state to say, oh, but we have all this other information? Or does the defendant, the petitioner, have the burden as normal in a PCR to say, well, here's all the other evidence that the state didn't disclose to us that shows that really there is a factual basis. And so that's just one hurdle. 814.29 does not require in a PCR the defendant show but for no factual basis. He wouldn't have pled guilty. So he doesn't have to prove that in PCR. But say the judge, the PCR judge says, oh, sure, there's a factual basis, or whatever the judge says. He then has to appeal. And if he's back on appeal under 814.29, he now has a burden on appeal that he didn't have in PCR court.
Explain that last part to me.
So,
What is the additional burden on appeal from the denial of post-conviction relief that wouldn't exist?
814.29 says on appeal, not direct appeal. So when if he appeals from a PCR, he now has the burden to show, but for no factual basis, I went to plead guilty, but he didn't have to prove that in the PCR court.
I mean, is 814.29 limited to direct appeals?
Doesn't say direct appeal.
Yeah, so it would apply in PCR. But, so what you're
It
saying...
would apply in a PCR appeal, but not in PCR.
Well, it says if you challenge a guilty... Yeah,
Text right now, and it just says that the plea shall not be vacated unless the defendant demonstrates the defendant more likely than not would not have pled guilty. It says challenges a guilty plea. It doesn't say anything about appeal or distinguishing between appeal and post-conviction relief.
The burden applies whether the challenge is made through a motion and arrest of judgment or on appeal. Doesn't say direct.
Excluding its application in any other context.
Yes. Because if you look at the other sections that the legislature passed in 2019, it specifies direct appeal in other sections. It specifies PCR and other PCR-related sections. 814.29 does not say anything about direct appeal, it just says appeal. So what can or should the court do? Does a factual basis matter? And, you know, we're at a stage where I can't say that my client is actually innocent. But when you look at the record, and there is nothing to show that he committed this offense. I double-checked the docket this morning because I couldn't remember, because unfortunately maybe age. I couldn't remember if there'd been discovery done. I looked at the docket this morning, and there's no motion for discovery. There's no motions for deposition at state expense. The police reports are attached to the minutes. There's nothing here. So what can be done? And does it matter? And so my suggestion to this court is adopt plain error, and it's not just going to be for this type of case, but plain error allows some discretion. No factual basis or, say, insufficient evidence really affects not just the client or the defendant. It in fact affects the integrity of this court.
Does the concern you're raising go away if Section 81429 were unconstitutional, to the extent that it imposes a standard that's different than what we've said as a constitutional standard, right? That when there's no factual basis, there's constitutional prejudice and vacation is required. Does the practical concern about post-conviction relief for you go away at that point?
I think that helps, but I also think that you have, I mean, if we're going to talk practical, practically, this court should be the court that reviews lower courts' rulings, if you have a record to do so, and you have a record to do so. So if everything goes into post-conviction, then you have another district court judge who is reviewing his colleague's factual basis determination. I also think that while appeals are not swift, I believe what you're going to see in PCR is going to be even more of a snail's pace for PCRs than they've been in years. Because all of these claims are diverted to PCR first. District court judges, county attorneys, and court-appointed lawyers are never going to keep up.
There are other jurisdictions that take ineffective assistance just about completely out of the direct appeal world, such as the federal system, right?
Right, but under the federal system, they have plain error. They would be able to review a forfeited claim, and under plain error, this fits. It's forfeited because the lawyer didn't do it, not because the client said, oh, I'd like to waive all of my rights to actually be factually guilty. So there are systems, and I looked at a lot of the cases, or a lot of the states that do not allow raising issues of guilty pleas on direct appeal. And interestingly, a lot of them had some exceptions. So, some of the states would have, you can appeal the denial of a motion to withdraw a guilty plea, but you can't appeal the guilty plea itself. So there's some balance of what states are doing. I did not find any cases specific to a factual basis. I'm not saying that those couldn't be found, but after so many hours on Westlaw Edge, you can't look at every single case there was.
We've repeatedly declined invitations to adopt a plain error standard. Is now the time to react to the statutory amendments?
I think now is the time, because there are going to be certain claims that are so plain that there's error that you can correct and save a lot of judicial resources. I mean, my two examples from the beginning of time have been no factual basis and insufficient evidence, because you're going to end up with cases where there is clearly insufficient evidence of the elements, but a correct motion for judgment of acquittal was not made. So that's going to get kicked to PCR.
We've talked a lot about practical concerns. Is there a constitutional right to present this factual basis claim on direct appeal? And what's your best argument for that?
In fairness, I don't believe that's what I raised, but I'm going to answer your question if that's okay. I think there is a due process issue if there is not a factual basis. I didn't raise it that way. I believe the court can get to where my client would like you to go without any of the constitutional decisions. But I'd like the court to know that this is not going to be the only case with this. So if you're going to look at good cause, no factual basis, should be good cause. What remedy do we have? Does he ever get a remedy? And I think that everybody here would say, and my time is up, and I can't see that as well as I should. I think everybody here would say there should be something to correct this type of error. And I'd ask the court to do that. Thank you.
Thank you. Mr. Miller?
May it please the court, counsel, my name is Zachary Miller and I represent the state of Iowa. The defendant in this case says that there's no factual basis for his plea to the gatherings charge. This court can't address that claim for 3 reasons. 814.6 and 7 deprive it of jurisdiction to consider an appeal from a guilty plea or an ineffective assistance claim. He did not show good cause to appeal. In 814.29, he can't show that he wouldn't have pleaded guilty but for the lack of a factual basis. Starting with...
Do you agree that on the record that's established that it's clear there was no factual basis? I mean, that's the linchpin of the argument I think we just heard, that, this gathering charge, if you look at the minutes and look at the record that was developed, there's, she says there's nothing there. What do you say?
I think that the state could probably establish a factual basis, but I don't know that on the particular facts in this record that one was established.
All right, so there is a plain error, and then I gather, I mean, it's a legal issue, and there's no factual basis to support it. Why should we end up sending this into a PCR where there'll be a number of problems? One, there'll be the delay that was talked about. Number two, there's a problem with getting a lawyer appointed. A lawyer appointed doesn't occur until after PCR is filed, and then it's only discretionary. You might not have a lawyer to assist you. You get in a whole series of problems in PCR. So why shouldn't we just take care of this now?
I think that there's 2 things, Your Honor. First, adopting plain error wouldn't solve the issue in this case because 814.6 still prevents this court from reviewing guilty pleas. Also, in other jurisdictions... Except for good cause, right? Well, that's true. And if the defendant had followed the correct procedure, which would be asserting that there was good cause to appeal the guilty plea, the state could have resisted if it so chose, and then this court could have either granted an appeal or denied the appeal and sent it to PCR.
Counsel, putting aside the question of what procedure to address good cause, in State v. Dame, we said good cause means a legally sufficient reason. In a challenge to a guilty plea, shouldn't we determine that lack of a factual basis is a legally sufficient reason?
I don't think so, Your Honor. I think that good cause should be interpreted to mean exceptional circumstances where no other relief is available.
If so, why didn't the legislature use that language?
Well, I think that if you look at the text of the statute, its structure in conjunction with the legislative history, I guess first I would say I think good cause is ambiguous. And so we go on and we look at that, and we have an exception to the rule that you can appeal, and that the defendant is obliged to establish good cause first. And then we also know that the legislature, from both those facts as well as the court said in Dame, conserving resources, and the legislature.
Oh, but if this is a straight legal issue, there's no point in going to see PCR. I mean, we've read your briefs; they're lengthy, and I'm not critical. The facts were explored and so forth. Isn't there good cause to consider a defective guilty plea on direct appeal when there's absolutely no benefit to sending it over to PCR?
No, I don't think so, because this isn't the only type of defect that can occur in a plea, and the statute provides a procedure for review, which is to file a motion in arrest of judgment and seek discretionary review. If you could do this, it would be reading out the good cause requirement. Why would you ever seek discretionary review and contest the error if you're going to arguably get a worse standard on appeal via 814.29, and you're also going to not have to go through the process of preserving the error and having the court have the first step of deciding whether to grant that review. So I think that that also suggests that good cause should be exceptional cases. And the legislature provided the procedure that should have been used here, which was a motion and arrest of judgment, followed by an application for discretionary review, and then this court could have either granted it or denied it and corrected the error. But since that didn't happen, there's the procedure of post-conviction relief, where the defendant can raise this issue, and it will be, decided however it's decided.
Setting
Give us
aside the good cause standard, the issue for me that seems troubling is Rule 2.24 is fairly clear that if a defendant doesn't file a motion and arrest of judgment, then he or she cannot challenge a guilty plea on appeal. And we've excused that in the past, either because there were inadequate advisories, which I don't think is this case, or by saying counsel was ineffective for not filing a motion and arrest of judgment. If we're no longer allowed to make or resolve ineffective assistance of counsel claims on direct appeal, how do we resolve that motion and arrest of judgment rule other than, I guess, ignoring it? It seems like that's the only possibility, but tell me if I'm wrong.
Well, I think that it's not, I guess I'm not tracking, because I think that the rule comports with the statute, which says that you file a motion and arrest of judgment, and then you seek discretionary review. If you don't do that.
I agree. Let me preface it this way. From the defendant's perspective, I guess,
Right.
the only way to address that issue is through an ineffective assistance of counsel claim.
Well, I think
right?
that, yeah, that's correct. Right. And this court will be able to review any ruling in that case on appeal from the PCR. So this court will still be able to review every guilty plea challenge that comes in the state of Iowa in one fashion or another. And I think that's why this isn't unfair.
Do you agree that with the reading of 814.29 that it does not require on PCR the defendant to show they would not otherwise have pled guilty but for the defect?
I think a PCR attacking an appeal is still, or a plea, is still challenging the plea. And so you would have to show that you more likely than not would not have pleaded guilty. I think that that is essentially the Hill v. Lockhart standard. I'm aware, of course, that this court has said that it's per se prejudicial, although it said that on policy grounds, which the legislature is allowed to set. The legislature can also provide the guardrail for constitutional claims, and their standards, for example, pleading standards for a constitutional claim, the legislature can control. And so I think that that's what it's exercised here. It's changed that standard, and the defendant needs to show that he wouldn't have pleaded guilty.
In a case, let's say, I'm not saying that's this case, in a hypothetical case where the defendant, in order to avoid more serious charges, pleads guilty to something for which there's no factual basis, there's really no remedy. That just stands. As offensive as that might be to our kind of gut as judges and as guardians of justice, right? There's no remedy?
Well, I think that the remedy is showing he wouldn't have, or she wouldn't have pleaded guilty had the error not occurred. And if you have a one-count indictment where the person's not guilty, or there's no factual basis at all, probably you can make that showing. But in a case like this one, where you're facing 6 counts and you have up to 203-year sentence and a 39-year mandatory minimum, if you're convicted at trial and everything's run consecutively, you can't make that showing. That's true.
I mean, but normally, it's a court system. We belong to the public. We don't just belong to the parties. We don't normally allow the parties to kind of contrive something that didn't really happen in order to get a particular result they want. Isn't that true?
That's true, and I think that this court has advisory, the administrative power to review attorney discipline, for instance, and has done so in cases where there's no factual basis. The people responsible for the error are able to be held accountable for the error, especially if it's an intentional thing. In this case, it seems like just an oversight. The defendant seems to agree that we could establish a factual basis on remand if we chose to do so. And this also is not a case where
Could the legislature change the standard for vacating the guilty plea when there's no factual basis if we've held that that's a constitutional requirement? And unless I'm misreading our cases, I think we have. We have said that it's a violation. Counsel's ineffective for allowing that to go forward, and that doesn't require any showing that the defendant would not have pleaded guilty, contrary to Hill versus Lockhart.
Sure. I think that the legislature can provide the guardrails for constitutional claims, and this is that. It's saying that you have to establish this standard to satisfy your constitutional right. I think that especially when you couple that with the justification that this court gave for those decisions, and Hack was particularly brief, was that it is public policy that it's offensive that it happens. The legislature can set public policy. If this court wanted to squarely consider the question on the merits of whether or not it should adopt Hill v. Lockhart as opposed to a per se prejudicial rule, maybe the legislature couldn't do that. But that's not what's happened so far in the development of Iowa's jurisprudence. And so I think that
Could the legislature say that the prejudice prong on Strickland should be higher?
well, no, the legislature can't change federal constitutional rights. Well,
Well,
I
and
mean,
how
it
about-
could, it just wouldn't have effect. I'm sorry, Your Honor, I can't hear you. I think you're
Oh,
muted.
I apologize. I was muted. If the prejudice rule is constitutionally based, that's not something the legislature can tamper with, correct?
If it is, no, I mean, you can't lower the constitutional standards of a federal constitutional claim. I mean, you can pass a
Or-
law, it just would be struck down.
Yeah, right. Let me ask you one other question. And your briefing and in oral argument, you raised it too. You say, well, you've got to breathe meaning in a good cause somehow, as I think you recognize, and you kind of say, well, exceptional circumstances. But I'm not sure I understand what that means. Can you give me examples of what would qualify as exceptional circumstance?
So as Your Honor is suggesting, I think it's going to be a case-by-case determination, and one possible situation might be a competency challenge, whether the defendant is mentally competent to proceed with a plea. That's possible. I don't know. I think that was the facts basically of Drain, I believe, one of the first three cases. That might be such a case. But I would encourage the court to consider, establish a type of practice where you seek to show good cause and then decide that on a case-by-case basis.
Well, and maybe so, but generally, good cause is a fairly expansive concept. I mean, I think context matters. Of course, context always matters. But ordinarily, it seems to me there's good cause is different than narrow cause, for example. No.
Yes, that's true. Those are different. I don't know of anything that's written as narrow cause, but I think as
Well,
you're,
exceptional circumstances strikes me as
sure,
narrow cause, frankly.
you certainly could have written that, but you looking at the structure of the act, at the legislative history, and its structure within the general criminal rules and appellate rules tell us that this isn't just something that's going to apply to every case. It needs to be a high exceptional showing, and that isn't.
The purpose of the statute, as I understand it, is preservation of judicial resources, concern about appellate courts wasting time on frivolous appeals, that kind of thing. Do I have the purpose correct?
It's also to resolve cases in the district court. That was,
Well, why? I mean, that's not a purpose. What's the underlying rationale of the statute other than
to
preservation of resources?
preserve resources both by requiring people to raise errors in the district court so district courts can fix them in the first instance. Had this been raised below, presumably we wouldn't be here. And I think the legislature was well within its rights to recognize that's an issue.
As a practical matter, is filing a motion and arrest a really realistic vehicle to challenge the factual basis? And I ask that as a former district court judge. you assume that a factual basis has been made, right? Like you work very hard to do that, and the parties do too. There's no transcript available within the time that you would appeal. Why would anyone, unless it's just blatantly obvious and they think about it and say, oh, we missed something, we have to go back. It seems as a practical matter, people would never file a motion in arrest of judgment to challenge factual basis.
I can't say whether that's true or not. I mean, a case like this one where it's an Alford plea and there's no kind of statement by the defendant of what they did to satisfy a factual basis, certainly the record is basically the minutes, and that's reviewable, and lawyers have an obligation to make sure that there's a factual basis to review those things and to preserve error. And so, yes, here, the lawyer could have looked at that and done that. And I mean, also, the defendant raises the challenge, so it appeared in the record, a lawyer did review it and decide that. I mean, it can be done, and that's what we hold lawyers to do, is to preserve error. I guess, just briefly, if the court were to reach the merits of this challenge, the remedy is to vacate the entire plea and allow the state to reinstate charges. And we would ask that you hold 814, 6, 7, and 29 all constitutional and affirm the defendant's convictions in sentence. Thank you.
Thank you. Ms. Lucey, you may respond.
I'm going to start backwards, or actually where he left off, I guess. If the court reaches the merits of this case, and I would urge you to do so, the remedy is to remand, to see if the state has some undisclosed information that is not in this record, to whether there can be a factual basis or not. This is not a case like Soretti where it can't be remedied. The Attorney General and the County Attorney have different authority and duties. The Attorney General's office can't tell the County Attorney that they should vacate the entire plea. The County Attorney, on remand, would get to choose whether or not the county wants to vacate the entire plea, or they don't. If you vacate the entire plea in the sentence and send it back, it could, again, it's just a waste of time if the county attorney says, we're good with 10. And then we're going to redo it and start from there.
Ms. Lucey, can I ask you just, I understand your argument about the practical concerns, and I certainly agree we can review a record for factual basis just as easily as a district court. But I want you to help me out with kind of this pinch point, for me at least. And it has to deal with the motion and arrest of judgment still. And so Rule 2.24 says, a defendant's failure to challenge a guilty plea by motion and arrest of judgment, quote, shall preclude the defendant's right to assert such challenge on appeal. And so your client here has not filed a motion and arrest of judgment. So how do we provide relief in light of that rule?
I believe that you still can say that this is a plain error, that it's forfeited by counsel. And you don't have to go into the ineffective assistance of counsel claim, because every case where there is a forfeited error could be ineffective. But instead of doing it that way, courts have said, let's just cut out blaming defense counsel for everything that goes wrong and address the error, fix it, and then the integrity of the judicial system.
You would, I'm not saying this is, you'd never ask for another context, but what you're specifically focusing on is the lack of factual basis in the guilty plea and then insufficient evidence where the case went to trial. Is that right?
Those are the two that jump out at me that are extremely concerning.
Yeah, because the concurrence I wrote in Rhodes, that was a guilty plea. And so, yeah, I see where you're coming from.
Right.
Yeah.
Analytically, it would be kind of a double plain error analysis, Right. It was plain error not to file the motion and arrest because it was plain error to have a guilty plea with no factual basis. That's, I mean, the same way we've
Yeah.
used ineffective assistance of counsel.
Correct.
Okay.
And, you know, you were saying, well, why would a lawyer file a motion arrest of judgment? Because everybody tries to do it correctly. Everybody tries to do it correctly. Sometimes it doesn't happen. Whose duty is it to find a voluntary plea and a factual basis? It's the judge's. The judge had the duty to find this factual basis. And that didn't happen. And so if it's always the defense counsel's fault.
Could I ask you this? Would we motivate judges to be alert for problems and fix them even when counsel don't object or don't raise them if we use a plain error standard? Which way would that, or would they relax, leave it to us to fix plain errors?
It's my opinion, Your Honor, that judges try to do the right thing, and that they would not necessarily relax, because whether it's an ineffective claim or it's a plain error thing, they don't want to retry cases. So judges and lawyers are going to try to do the right thing. And it's not sandbagging or counsel's just going to wait, because how many lawyers want their client to go to prison for 3 years because they wanted to hide their objection? That's probably just not realistic.
Counsel,
No judge wants to, on Wednesdays and Fridays, no district court judge wants to be reversed by the appellate court. So they try, but, so if what you're saying is plain error can substitute for ineffective assistance of counsel, tell me how that's consistent with the legislature's intent to prohibit the presentation of these types of claims on direct appeal if we just effectively do what the statutes, assuming they're constitutional, have disallowed.
What we have for legislative history is one senator saying, we think that the appellate court's wasting our time, they're addressing all these things without anybody having a chance to respond. And with a plain error, it doesn't matter why counsel may have chosen something. And again, with a plain error review, it's discretionary. If you think that there might really be some legitimate reason, not just, oh, there might be, but there really might be, then you can decline to correct the plain error and let the defendant go to PCR and do it through ineffective assistance of counsel. What we have is the idea that this court has no duty to secure justice. And that's the second part of the clause in Article 5, Section 4, is that you shall have the power to issue all writs and process necessary to secure justice to the parties. Legislature can't take that away from you, because that's not subject to a manner or a restriction. So you have the ability to do that, whether it's going to be through an actable ruling. And I'm not saying that you need to do that in these cases, because you have another avenue. And if you have another avenue that will secure justice and protect the integrity of the judicial system, and let's face it, protect defendants' rights, then we
You
should
may wrap up.
Then we should use it. And I'd ask this court to reverse and remand for the opportunity, if possible, for a factual basis, and if not, let the state, through Buchanan County Attorney's Office, decide whether they want to proceed. Thank you.
Thank you. The case of State versus Treptow has been submitted to the court. In between the next two cases, the court is going to take a recess from the bench for 10 minutes, and we will reconvene in 10 minutes for the case of State versus Tucker.